Welcome to the Smart Legacy Podcast, your resource for protecting assets and securing your future. Hosted by Stockton and Kandt, join us as we cover essential estate planning and elder law topics, such as wills, trusts, and Medicaid planning. Stockton and Kandt, your trusted attorney advisors in safeguarding what matters most. Welcome to another episode of the Smart Legacy Podcast. I'm your host, Glenn Stockton, managing attorney of the law firm of Stockton Kandt. We have offices in Overland Park as well as down south in Gardner, Kansas. Today, we're going to cover the topic of the estate plan stress test. 8 questions to ask before it's too late. If you can answer these clearly, you're in good shape. If you can't, you found the gaps that matter most. So, before we get started, I would like to say this. Estate planning is not just about documents. It's about real life. It's about what happens when life changes. A health event, a crisis, a loss, a transition. And what I've learned over the years is that most families don't struggle because they don't love each other. They struggle because they don't have clarity. And clarity changes everything. So this episode is designed to give you clarity. I want you to approach this like a checklist. You don't have to solve everything today. You just need to identify what matters and what might be missing. All right, let's get into the estate plan stress test. Question number 1, if something happened to you tomorrow, who's in charge? And do they know it? This is the first stress test question because it's the one that causes the most panic in real life. If you were in the hospital tomorrow and you could not communicate clearly, who makes medical decisions? Who talks to the doctors? Who handles the bills? Who manages the bank accounts? Who has the authority to act? Most people assume the answer is their spouse or their adult children, but thinking someone is in charge is not the same thing as legal authority. Hospitals and financial institutions do not run on good intentions. They run on documentation. So the stress test question is, do you have the right lifetime documents in place? Do you have a durable power of attorney for finances? Do you have a healthcare power of attorney? Do you have a HIPAA authorization? Do you have a living will? And just as important, do the right people know where those documents are located? If you can answer that clearly, you're ahead of the game. If you can't, this is a gap worth closing. All right, question number 2. Do I have a plan that works while I'm alive, not just when I'm gone? For many families, the centerpiece of their estate plan has been a will. And wills can work, but wills work through probate. Probate is court supervised. It can be time-consuming, expensive. It's public. More importantly, a will does not do much to help you during your lifetime. In fact, it really does nothing other than give you peace of mind. And this is one of the reasons trusts have become preferred planning tools for so many families. A properly designed trust can avoid probate. It can maintain privacy. It can provide flexibility. And that's the key. It's the difference. A trust works while you're still alive. It is a powerful disability incapacity planning vehicle. So the stress test is simple. If you were alive but you're incapacitated, does your plan protect you? Or would your family be forced to go to court to get authority through conservatorships and guardianships? If your plan only turns on after death, you may be missing the most important years of planning. All right, question number 3. If I have a trust, is it fully funded? Are my assets in the trust? Are they in the safe? Or is the safe empty? This is one of the most common gaps we see. People sign their trust documents. They feel relieved. They feel like they've got their plan done. They feel good about it. But they never get the assets into the trust. And a trust is only as effective as its funding. So here's a simple way to think about a trust. Think of a trust as being like a safe. It's this legal safe. The trust is that safe. The trustee or trustees, that's the person or people that have the keys. The successor trustees have the backup keys. So by far the most common type of trust we have is the revocable living trust. Right? So the trust makers, the people who create the trust, let's say I've got a husband and wife situation, they create this joint revocable living trust, this joint safe. Typically, they're going to keep the keys to the safe. They are the trustees. They each have a key, right? Those keys work independently of one another, just like with a joint checking account or, that husband and wife have. Either one of them can write checks. Either one of them can make deposits. Either one of them can go down to the bank and withdraw every last nickel, and they didn't need the permission of the other to do so. The same thing with the trust, right? They've got this joint revocable living trust. They each have the key, meaning they can independently act. But funding means now instead of them owning their checking account in their individual names as joint owners of the checking account, we move the checking account into their joint trust. We move their home and other assets into the trust. So funding the trust means putting the assets into the safe, getting them into the name of the trust. If the safe is empty, the trust cannot do its job. So the stress test question is, are your key assets properly aligned? Is the real estate properly titled into the name of trust? Are the bank accounts titled correctly? Are the investment accounts titled correctly? If you're not sure, this is not something to ignore, because an unfunded trust or just a plan that doesn't properly align with the assets often leads to the very thing that the plan was designed to avoid: confusion, delay, and probate. So make sure you get it done. All right, question 4. Are my beneficiary designations aligned with my plan, or are they working against it? This is one of the most overlooked areas of estate planning. Many major assets pass by way of beneficiary designations for a lot of people. Retirement accounts, life insurance, annuities, transfer on death accounts. Now, if we have a trust, I can't put the retirement accounts in there, but I want those other assets typically titled in the name of the trust. I want to get them in the safe. But if we're not using a trust, or we're using a will-based plan, then we're going to use beneficiary designations. So are these assets, do they follow the terms of your will? Are they going to the people you want? Are they working together? Because they do not automatically, go to who you named in the trust or the will. If you have a trust, you have to get the assets into the trust. Then the trust controls them. Right? If you have a will, the will can say, I want everything to my spouse dies, then it goes to my kids. But if your beneficiary designation says something differently for that asset, the beneficiary designation is going to be the controlling document. So they follow the beneficiary form. So the stress test question here is, have your beneficiaries been reviewed recently? Do they reflect your current wishes? Do they align with the structure of your plan? This is especially important after major life events: marriages, divorce, death of a loved one, birth of a child or grandchild, changes in relationships or priorities, changes of jobs. If you've not reviewed your account titling and beneficiary designations in the last 12 to 24 months, you are due. We like to do the annual review meeting every year. We want to go through, we want to look at the assets and make sure they're titled properly, beneficiaries are set up correctly. Right? So you want to look at that periodically. All right, on to question number 5. Do I have a plan in place to avoid guardianships or conservatorships if something happens? Most families don't think about this until it's too late. If someone becomes incapacitated and there is not enough legal authority in place, we haven't done any estate planning, families can be forced into court supervision just to handle the day-to-day life through guardianships or conservatorships. So when we don't do planning, we haven't planned. The state has a plan in place for us through the guardianships and conservatorship situation. So let me walk through that a little bit. Let's assume I've got a husband-wife situation, but this could apply even if somebody's not married, but I'm going to use a married couple situation here. So I've got a husband-wife, and husband has a stroke or something happens. He's still alive, but he's unable to make decisions for himself. He's incapacitated. Dementia, Alzheimer's, stroke, something along those lines. So let's say he had a stroke. A lot of people assume wife just has the authority to make decisions, do whatever she needs to do. But wife's going to figure out very quickly, if husband had done nothing, if there's no planning in place, that it doesn't work like she thought it would. She's going to figure out she doesn't have the authority to make healthcare decisions for her husband. He never authorized her to do so. Right? She can't make those decisions. Our kids, when they turn 18, right, now they're adults. We no longer have the authority to make decisions. So here, wife's going to figure out she can't make decisions. And if husband never even signed a HIPAA authorization, he's incapacitated, the doctors, the healthcare professionals, they can't even talk to wife about husband's situation, his health. They can't disclose any of that information because he never authorized her to do so. So she's going to figure out she needs help. On the financial side, she's probably also going to figure out she needs help there. She'll have access to the accounts that are jointly titled, that she's on there as a joint owner, but she has no authority over husband's retirement accounts, his IRAs, 401ks. Those are individual accounts. He never authorized her to make decisions, so she has no authority there. She doesn't have authority to deal with the Social Security Administration on behalf of her husband, or health insurance, or Medicare, billing questions, coverage. She doesn't have the authority because he never gave her that authority. Husband never did any planning. So wife's going to figure out very quickly that she's going to need help. And she's probably going to need to seek out the assistance of an attorney, right? Because going through this process of setting up conservatorships and guardianships, well, you could do it without an attorney. It would be difficult, right? That's very rule-driven, process-driven. So she's going to go hire an attorney and petition the court. And let's assume she's requesting that she be the one that's appointed as her husband's guardian and conservator. Before the court's going to appoint her, right, the court's got to make sure, does husband really need a guardian? Does he need a conservator? And is wife the appropriate person to do so? So before the judge is going to appoint wife to play that role, he wants to make sure it's actually needed. And the judge is not climbing down off the bench and headed to the hospital to go visit with husband to see if he really needs one. The court is going to require that husband be represented by his own attorney. So now at a minimum, we have two attorneys involved in this process. And let's assume that the attorney for husband goes to the hospital, visits with husband, says, yep, he absolutely needs somebody to make these decisions. He can't do it on his own. Visits with wife and says, yeah, I think she's the appropriate person, and comes back to the court and reports, Judge, we agree. We consent to having wife appointed as husband's guardian and conservator. Right? We had to go to court to do this. We've had two attorneys involved. At that point, the court's going to make a finding, and husband is now considered to be a ward of the state, and wife is appointed to represent him as his guardian and conservator. Guardian is the person that's appointed to represent him as an individual, to make sure he's receiving proper health care, to get health care information, to make sure he's properly clothed, has properly, proper living arrangements. The conservator is the person that's appointed to manage the money and the property. So in this situation, and this would be common, wife's appointed to play both of those roles. Husband's now ward of the state, so the court's going to require that wife file annual reports, annual accountings, every year with the court for the rest of husband's life. So I want to be clear, even when families are loving and united, court involvement is stressful, it's time-consuming, it's expensive, and it creates a level of complexity that families never expected. So the stress question here is, if I became incapacitated, would my family have the immediate authority to act, or would they have to go to court first? If the answer is court, that is a gap worth closing. All right, on to question number 6. Do I have a forward-looking tax plan, or am I simply doing tax filing? Most people think taxes are simply something you deal with each spring, right? You get all your 1099s and W-2s and other tax paperwork and your receipts. You pull it all together, you prepare your return, you file it. What I call microscope tax planning. Guys, it's important. We need to do it every single year. But that's only half of the planning. True tax planning says not only do we look at it through the microscope, but we want to be forward-looking. We look at your situation through the telescope. So is your tax planning strategic? It involves looking not just at this year, but to the next year, 10 years, 20 years. Retirement has tax traps. People don't anticipate. Required minimum distributions, RMDs. Right? Current law, age 73, you've had this money in these retirement accounts, your IRAs, 401ks, 403bs, 457s, these retirement accounts. And in a traditional retirement account, you put that money in on a tax-deferred basis. You never paid taxes on it. You deferred that money from paying taxes. And it's been growing, tax-deferred for a lot of years. And under current law, age 73, Uncle Sam and Aunt Iris, right, the IRS, they show up at the back door and they're knocking. And they say, hey, you've never paid tax on this. You got to start taking money out through what are called your RMDs, required minimum distributions. And it's the same formula for all of us as far as how much you take out. The only thing that matters, how old are you and how much money do you have in those tax-deferred accounts. Now, by the way, it's age 73 unless you were born 1960 or after. For those people born in 1960 or after, the law says they're not required to take their required minimum distributions, to start taking them until age 75. But if you were born prior to 1960, age 73. So if you're taking RMDs now, required to take them, means you were born before 1960. So you have to take that money out whether you like it or not. What are those RMDs, those required distributions? What's it do to your taxes? Well, it's pushing you up the tax ladder. Why? Every dollar that comes out is income to you. Right? You put it in on a tax-deferred basis, so what you put in was not taxed. But now, when you're taking it out, it's not just what you contributed. Typically, most of the money that's in those accounts is the growth on the money. And you're taxed on all of it. So when Uncle Sam comes knock the back door, when you take a distribution, when you take it out of the IRA, it's income to you. It's pushing up the tax ladder, pushing it potentially into higher tax brackets. It's affecting your Medicare premium because Medicare premium, Medicare's our insurance we get at age 65, right? But the premium you pay is based on one thing. What's your income? It doesn't matter male, female, pre-existing conditions, whether you're a smoker or didn't smoke. None of that stuff matters when it comes to Medicare. The only thing that matters is what was your income, and it's looking 2 years behind. And if you're blessed to have higher income in retirement, you're taking that money out of the retirement accounts, you had a lot of money in there, so you've got good income, you're going to be blessed to pay higher Medicare premiums. The survivor trap. This is one of the things where I find nobody's planning for this stuff. We can see it coming, guys. We can see how the RMDs are going to affect us, but nobody's doing anything about it because we're only looking at our taxes through the microscope. We're not planning for this stuff. One of the things we can see coming, so back to my married couple, right? They hadn't thought about this stuff. They're both alive. They're filing a married filing jointly tax return. They got two sets of deductions. Right? They're in a married filing jointly tax table. And they both have their IRAs, right? They're taking them out. But then husband dies. Who's typically the beneficiary of husband's retirement accounts? Wife, right? The spouse. So now she's got her own RMDs from her own retirement accounts, but now she's required to take money from husband's retirement accounts. She's got to take both of them. But we just lost half her deductions, right? She can't file a joint two-person tax return anymore. She's filing a single filer tax return. So she lost half her deductions and her tax bracket got cut in half. She's now in the single filer tax bracket. What's that done to her tax table, right? Her tax rate. It's pushed her up. Probably pushed her into higher brackets. What's it done to her Medicare premium? It's gone up, right? It's pushing it up because Medicare premium is based on her income. It's also her Social Security is being taxed at higher levels. She may have now been phased out of certain tax deductions. Guys, we can see this coming, right? We've got these IRA accounts. We're filing a married, filing jointly account. The chances of both husband and wife dying within the same tax year are not that high. It could happen, but generally one dies and we got a survivor. And that survivor goes to a single tax filer. We see it coming, but nobody's doing anything about it because we're not looking through the telescope. We're not planning ahead. So we want to make sure that we're paying attention to this. So if no one is looking ahead, you may pay more taxes over time than you need it to. So the stress test question is, do you have anyone helping you see around the corners? Are you coordinating tax decisions with your retirement planning? Are you thinking about how to minimize taxes, not just this year, but over your lifetime? All right, question number 7. Have I communicated the plan, or will my family be forced to guess? This is where good planning becomes great planning, because even the best legal plan can still create stress if nobody knows it exists. So ask yourself this question: do the right people know who's in charge? Do they know where the documents are? Do they know who to call? Do they know what you would want? A plan you never communicate becomes a plan your family cannot use. And one of the greatest gifts you can give the people you love is clarity, because transparency today brings peace tomorrow. So the stress test question is, have I made this easier or harder for the people who may someday have to step in? All right, now we come to question number 8. If I needed assisted living or nursing home care, what's the plan? How do we pay for it? This question matters because for many families, the greatest financial risk does not come at death. It comes before that. It comes when a fall, a diagnosis, or memory loss turns into long-term care needs. And the cost can be staggering. Nursing home costs regularly exceed $100,000 per year. And without planning, even families who save diligently can watch their life savings disappear in just a few short years. Now, I want to say this carefully. This is not about fear. This is about options. When families plan early, they keep options. When families wait, they lose options. And one of the biggest points of confusion is Medicare versus Medicaid. Many people assume Medicare covers long-term care. It does not, at least not the way people think. Medicare is designed primarily for, hospital stays, prescription drug benefits, paying for doctor visits. It's not designed to pay for long-term care. It has very limited ability to pay for long-term care, right? It will pay up to a maximum of 100 days of skilled nursing care for rehabilitation purposes following a qualified hospital stay. Maximum of 100 days, and let me tell you, rarely do people get the full 100 days because they either determine you're not progressing fast enough, the rehabilitation's not working, not progressing fast enough, and they kick you out, right? Medicare says, no, we're not going to pay for it anymore. You're not progressing fast enough, the rehabilitation's not working. Or they say, hey, rehabilitation's going great. You've got it now. You don't need it anymore. You've done great, and they kick you off because you progressed too fast. So Medicare is not designed to pay for long-term care. Medicaid insurance is what's designed to pay for long-term care. But eligibility rules are strict. And without planning, families often face painful choices, and they have to go through what's called the Medicaid spend down. Here in Kansas, they got to spend down to $2,000 or less. So the stress test question is, if long-term care became part of your story, and for 70% of us, it will be statistically. So if long-term care became part of your story, do you have a plan? Or would your family be forced to figure it out at the worst possible time when you're already seated at the admissions desk at the nursing home, or at least you have a foot in the door? The best time to plan is before you need care, not at the nursing home admissions desk. All right, so let's recap the 8 questions. If something happened tomorrow, who's in charge and do they know it? Do I have a plan that works while I'm alive, not just after I'm gone? If I have a trust, is it funded or is it an empty safe? Are my beneficiary designations aligned or working against my plan? Do I have a plan to avoid guardianship or conservatorships? Do I have a forward-looking tax plan, not just tax filing? Have I communicated the plan, or will my family be forced to guess? And if I needed assisted living or nursing home care, what's the plan and how would we pay for it? If you can answer these clearly, that's excellent. If 1 or 2 made you pause, that's normal. But those pauses are valuable because they show you exactly where the gaps are. And in most cases, those gaps are fixable. And once they're fixed, you get clarity. And with clarity comes peace of mind. If you've been putting planning off, I want you to do one simple thing this week. Get clear on the gaps and take the next step, because peace of mind doesn't come from hoping things work out. It comes from knowing you have a plan in place and knowing your family will not be left guessing. As always, I hope you found today's episode relevant and helpful in allowing you to leave the legacy you want to leave. If you enjoyed today's episode, I would encourage you to subscribe and share the Smart Legacy podcast with someone you care about. You can find us on Apple Podcasts, YouTube, and Spotify. You can also visit our website at stocktonlaw.com, where you'll find links to all episodes of this podcast, along with a plethora of other useful information, including our new legacy guide. This legacy guide, and you'll be able to download it from our website or from the show notes from today's episode. Just enter your name and email address, and we'll send this to your inbox. But it's going to help walk you through this process and help you close those gaps. So thank you again for listening. This is Glenn Stockton, and I hope you will tune in to future episodes of the Smart Legacy Podcast.
The information provided in this podcast is for general informational purposes only and does not constitute legal advice. Listening to this podcast does not create an attorney-client relationship. Laws vary by state, and this podcast focuses on estate planning and elder law in Kansas and Missouri. If you are located in Kansas or Missouri and require legal advice, please contact our office. Otherwise, consult a qualified attorney licensed in your jurisdiction.